Hello and welcome to episode 120 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh DeHaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Gyn, the CCF's new interim executive director. And Josh, I think now you're the interim
That's right.
litigation director because Joanna is away. She just gave birth to adorable little twins, and we're all very happy for her. So, in today's episode, I'm going to tell you about a trial getting underway in British Columbia that is considering whether freedom of the press was violated when police arrested a photojournalist at a pipeline protest.
And I'll explain why I'm worried that Manitoba has expropriated a nursing home. Plus, we'll share our bad legal takes of the week.
But before we get to that, I wanted to introduce all of our listeners to our new counsel, Alexander Surgenor, who's going to be taking over for Josh while Josh is interim litigation director. And because the team is growing, we have so many cases and so much going on, we needed to bring on a new constitutional lawyer, and that's going to be Alex. And he's also going to be our new podcast pinch hitter. So if Josh or I are away, Alex is going to be joining. And Alex completed his undergrad at University of Toronto, just like me, and he got his JD at Osgoode Hall Law School, also like me. And while in law school, Alex wrote for the student newspaper. He served as a mediator with Osgoode's mediation clinic. He was called to the bar in 2024 and then worked as a criminal defense lawyer in Ontario and in Saskatchewan, representing clients at the superior, provincial, and appellate levels of court. And Alex, we're not going to make you walk us through a news headline since you literally just started this week. But what we do want to do is a little lightning round so that listeners can get to know you. So we've done these before. We're just going to ask you some quick questions and give us an answer so people can get to know you. So we're going to start with, what do you think is the worst Supreme Court decision of all time?
Good morning to you both, and happy to be here. This is going to be maybe surprising. The answer is Oaks, because I don't particularly like the way that it's vague. It's vague how we define that exception, and I could go on forever, but this is a lightning round.
Yeah, Oak sucks. I totally hear you. So best Supreme Court decision of all time.
This is a cop-out. It's the patriation reference. Just so much to work with. I'll leave it at that, but we could go on again in that case forever.
And I think we actually asked you this in your interview, but who's the worst premier in Canada for freedom?
So many options.
There are many. As an Ontario resident, I'm ambivalent towards Mr. Ford. I'm supportive in some ways. I'm a bit of a detractor in other ways. I don't know if I'll ever get over what happened in the COVID era and the decisions that were made at that time. So my apologies perhaps to Mr. Ford, but I think that's my answer for the time being. Perhaps it'll change. I hope not.
Yeah, I'm going to be dragging a couple of premiers later on in this show. Okay, so this is an interesting one. What do you see as the biggest existential threat? And there's three options here: AI, climate change, or nuclear war.
Well, I think nuclear war is a popular answer, and I think it would be a pretty quick, pretty quick event. So God forbid that ever actually happens. I think between the other two, though, it really depends on what you're looking for. I think that AI is a little bit more insidious. It's got the potential to be very helpful, but if we become too reliant, I think that doesn't bode well for anyone.
So this question we asked each other a few months ago when we did the lightning round. I think it's a little bit easier for a lot of people now, but who do you pick? Katy Perry or Taylor Swift?
Katy Perry, but I'm not very supportive of her romantic dispositions of late. So
Clearly a straight man if you're picking Katy Perry over Taylor Swift. Okay, Drake or Kendrick?
Kendrick, because I despise Drake.
Same, same.
You guys, hometown boy, Drake. Don't break my heart. Okay, John Stuart Mill or Edmund Burke?
And Edmund Burke is the classic answer, but I think John Stuart Mill has a lot to offer, but I like the word Burkean, so Burke.
Interesting. Okay, who's the bigger threat to freedom in Canada? Is it the judges or the politicians?
It has to be the judges because as we know as lawyers, laws are made and then they take on a life of their own sometimes, and most often that happens in courtrooms. And so I think the answer is judges.
Okay, what's your favorite podcast? Obviously, other than this one.
I This is a bit of a cop out because it's a radio show that becomes a podcast. So if it's not hardcore history, I'll put that aside. I love listening to the guys on TSN cover Toronto sports. It's a guilty pleasure. I listen as often as I can. That's the Overdrive podcast. It's your prime time driving hour. I listen to them more than I should.
I feel like you're probably the only one on our team who listens to that one. I don't think
Correct.
Josh or Joanna or I even know what you're talking
No,
about.
it's
It's a
good to have
radio
somebody
show.
who can. It's good to have somebody who can talk sports. Finally. Okay, so I know you've spent a lot of time in Saskatchewan, so you might be biased here, but what's the most underrated city in Canada, in your opinion?
You're on the right track, Josh. It's Saskatoon. Saskatoon is such a beautiful place. I've seen it in all four seasons, and it's beautiful year round. But there's something about that river in the summer. It's people sleep on Saskatoon.
And what's the most overrated city in Canada? This one's always a controversial one. You have to pick.
Yeah, I think I can't speak for places I haven't been. So I think that Montreal is a lot of fun, but it's not as fun as people I think pretend it is.
That is sort of what I said. That's what I said. I got some pushback because Joanna and Josh are big Montreal lovers. My thing with Montreal is everyone says it's like going to Europe. It's like,
I
dude, have you ever been to Europe? It is not like Europe. So that is
exactly.
the reason I picked it.
Okay,
Hmm.
the work-life balance is a bit like Europe, so that's I think part of what I like. Biggest threat to free speech in Canada.
I think just I think paranoia, a culture of a culture punctuated by a kind of lack of confidence. And so when people can't speak freely or feel they shouldn't, it really can have disastrous spillover effects. And I think that that has to be addressed head on.
And what is something that makes you hopeful about the future?
Honestly, many things. I think, though, that top of mind would be the fact that people, and I think of my brother, who's about 5 years younger, seem to be more attuned to what's going on politically, and that goes for everybody all over the political spectrum. But to me, it's a good thing when people are when the younger generation is becoming more and more interested in politics. I actually am. That makes me happy. I think that it's important because, as I said just a second ago, the idea is more dialogue is better than less. So it's that makes me optimistic.
All right, well, that was fun. Welcome, Alexander, and I look forward to hearing your bad legal take later in the show.
Yes.
Let's turn to our news headlines and something that makes me not feel very hopeful. And that's the fact that the Manitoba government has decided, in an unprecedented move, that they're just going to expropriate, that is, take a personal care home that belongs to private owners. So the private owners being legally forced to sell to the government after negotiations to buy it failed. And I don't have all the details here, and I don't want to speculate too much on what the private owner planned to do with this building, but we do know this was not a voluntary sale, and I would argue this is thuggish behavior on the part of the government. So, according to CTV Winnipeg, the owners of this 78-bed Golden Door Geriatric Center plan to stop operating as a care home and as a result had been not filling up beds as they became available. And the government didn't like that and they wanted it to continue to operate as a care home, so they tried to buy it and negotiations failed, so they decided to just take it instead. And of course, that doesn't mean they won't get any compensation at common law and under most statutes. The government is required to compensate the owner for fair market value based on something called highest and best use of the property. I won't get into highest and best use, but that can be a little bit tricky to determine. In any event, expropriations, they can in some cases, I think, be reasonable. The extreme libertarians that listen will like be saying that, but if you're building, a huge public highway or a train line, it can make sense in some cases to expropriate property where needed. But expropriations are much less justified, in my opinion, when the government wants to build something that they could just build by acquiring land or buying buildings on the private market, which seems to be the case here. If they're worried about losing 78 care beds in a care home facility, why not find a place to buy a building nearby or build 78 new care homes on the private market? This is also part of a disturbing trend in Manitoba from the Wabkanu NDP government. Last year, they actually started the process to expropriate privately owned land slated for redevelopment because it contained a cemetery for an orphanage that some members of the public didn't want to see any development happening near. They want to continue to be able to access that, even though it's on private property. And you know what? The the developers were planning to build there a 5,000 person private care home. So if the government had allowed that to happen, they wouldn't be worried about losing 25 or 78 beds now. So expropriations like this are bad for the economy, really bad for the economy. The power of strong property rights is that they allow for economic growth that benefits us all, because when people know that the state's going to protect their exclusive use of the property, it gives them the confidence to raise money and build projects like long-term care homes that we all need. You have to ask yourself, if you're an investor investing in long-term care homes or even private property development, are you going to put your money in Manitoba now that they've twice decided they're just going to take property that doesn't belong to them? And this is not just a Manitoba issue. I said I was going to drag a couple of premiers today. As we discussed before, Ontario's PC government is involved in an expropriation in Ontario here of farmland in Wilmot Township, so that the government can sell it or lease it to factories. It's rumored to be related to their drive to build electric cars in the province, which so far has failed to materialize. Which brings me to another reason that expropriations like this are just so evil. The invisible hand of the market is just much better at determining how best to use land compared to government. Governments picking winners and losers doesn't tend to work out very well. They tend to have limited information and ulterior motives, and they often make really dumb bets on where the markets are going and what people actually want. So I don't like this. I don't like these kinds of expropriations. Christine, are you as worried about private property in Canada as I am?
I mean, this one is weird because it seems like they're doing more than just taking the land and the building. They're like nationalizing the business itself, right? Isn't that what's happening in this case?
I don't know if that's technically what's happening, but I think that
That's what
more or
it looks.
less
Yeah,
that's
I mean,
they want these to be public beds that they will just fund themselves, right? But
I mean, that just does not seem like a good idea at all. And look, I know how expropriation works. If the government decides to take property, they can do it. They just need to pay the compensation. And, looks like, an outright expropriation, not a constructive taking. The constructive takings are really concerning. That's when the government takes the property but claims they didn't. They change things by regulation. So they de facto have expropriated the property, but they haven't explicitly said so. Do you know how much they got compensated?
it's still being negotiated.
Yeah, I mean, this just seems like a really dark direction that things are going. Um, And if they can do it with this business, like where are they going to stop? What other businesses
Exactly.
are in the province's interest to take control of and seize? I mean, this kind of stuff is pretty dark. Alex, do you have any high level thoughts hearing about this?
Well, I think that expropriation is a prickly one because, as Josh said a moment ago, it can be of value. I'm skeptical, and there should be a far more transparent process. Um, it is troubling though that with the wave of a magic wand, so to speak, notwithstanding those Josh got into it briefly about how they justify taking the land, but nevertheless, on a visceral, instinctive level, it's something that should give us all pause when government can say, well, we need this, and so tough.
Yeah. All right, so I'm going to talk about my headline, which is about a case that's going on right now. It's called the Narwhal and RCMP. So this is a 5-week trial that began on January 12th. The Narwhal, I think it's Narwhal. It's a
Narwhal.
Narwhal, sorry. It's a West Coast online publication. I would characterize it as progressive. They are suing the RCMP right now. So here's the background. In 2021, a Narwhal photojournalist named Amber Bracken was on assignment at an anti-pipeline protest. So she was documenting the police removal of protesters who these protesters had been blocking access to the Coastal GasLink pipeline construction. This is a pipeline that was being constructed on Wet'suwet'en Indigenous territory. And Coastal GasLink had obtained an injunction to have the protesters removed. So the protesters had built some structures, like a tiny house, and Coastal GasLink had obtained this injunction, and the protesters were still inside this exclusion zone where they had built this structure. And on November 19th, 2021, the RCMP raided that structure, the tiny house, and photojournalist Bracken was inside, along with 5 Indigenous protesters and a documentary filmmaker. All of them were arrested. Bracken was held in custody for 3 nights, 4 days. She identified herself as a journalist when she was being arrested, and there are photos of her arrest that show she had cameras around her neck. She was wearing a press badge. And according to the Narwhal, they had told the RCMP that they had a photojournalist in the area. So now the Narwhal is suing the RCMP, seeking declarations from the court that Bracken's liberty rights and the Narwhal and Bracken's press freedom rights were unjustifiably breached. And they're also suing for damages for wrongful arrest and detention, as well as that interference with their constitutional rights. So the trial is underway. It's pretty interesting because it is about the scope of press freedom and this question of when journalists have crossed a line to become a part of the protest. So the Globe and Mail has reported on some of the things that have happened on the trial so far, like Bracken's cross-examination. Bracken was questioned by the defense about why she didn't identify herself as a journalist as the police approached the tiny house where she was taking photos. So this is before the arrest. She was asked why she didn't, hold her letter of assignment or her press pass up to the window of the tiny house for the police to see, and why she didn't yell out the window, "Hey, I'm here with the Narwhal. I'm just taking photos. Just make sure you know." These were the questions that the RCMP lawyers asked. And, when police announced from outside that those inside the cabin were under arrest, did she ask the protesters closest to the door? Why didn't she ask them to tell the police that there was media inside and for them to clarify whether the arrest was going to apply to her? She was asked, was there anything preventing her from removing the barricade from the door? Why didn't she consider leaving through a window of the tiny house? Bracken responded to these questions by saying that this would have been an unusual derailment of the unfolding events that she was there to document. And I have to say, I am sympathetic to that answer. It is very important to document police actions at protests and in the course of an arrest. That is part of the role of the media. The defense counsel also gave an opening statement where they said the charter does not give members of the media the right to ignore court orders or the law. And as reported by CBC, they said that defense counsel said Ms. Bracken's detention followed a lawful arrest. It was not arbitrary. Her work as a journalist does not immunize her from or minimize the consequences of failure to comply with a court order. And the RCMP is under no obligation to give her preferential treatment. Now, I have no idea if Miss Bracken was more of a journalist or more of a protester. I think that this case will likely come down to the facts. But what I will say is that we are in an evolving media environment where we do see activist journalists. I don't know if Ms. Bracken was one of them or not. I'm actually leaning towards her position. She works for a real outlet. It's not like she's reporting for a personal blog. But when you consider what the police were dealing with, it kind of complicates the picture. The CBC has reported on the conduct of some of the other journalists at the protest site. So there was evidence given by a senior RCMP officer who was coordinating the enforcement. His name's John Brewer, and he said that journalists were permitted to go through an access point that had been set up by police, and anyone who claimed to be media was allowed in. He said that people claimed to be journalists at the protest and they were allowed to go through unless their story, to quote him, beggared belief. And in some cases it did. He told the court that he had seen examples in the past where people claimed to be media and then just walked past the police, then linked arms with the protesters and sat down. And that was after they had been granted access by police. And he said police didn't question media credentials. He just judged the conduct of the people claiming to be media based on their actions. And he said that he'd made the determination that the filmmaker who was arrested with Bracken was not media. And that was based on his, what to quote Brewer, his quote, aggressive behavior towards officers. He said it was his decision, though, to release a different filmmaker, a woman named Melissa Cox. And she was also arrested during this whole series of events but she was released and given an apology because the police thought that she had done everything the police had actually asked of journalists. So I am still sympathetic to Bracken, this narwhal photojournalist, because I kind of fundamentally do not like the idea that the RCMP just subjectively decides who is a journalist and who isn't. I get that there are people who falsely claim to be journalists, and maybe more is going to come out about Bracken's conduct that I don't know at this point. But I think if we're talking about the overall balance of the police need to enforce the law and enforce an injunction and an illegal protest on one hand, and our constitutional rights to a free press on the other hand, I just think that the balance needs to tip towards freedom of the press, especially when we know how important it is to document police conduct at protests. I mean, to make an American analogy, if we didn't have people documenting protest and police interactions in Minneapolis, we wouldn't know about a lot of what's happening at those protests. So, Josh, where do your sympathies lie here? I still think a lot of it's just going to come down to the facts, and I don't know all of the facts here.
So it's interesting. I have so many thoughts on this as a former journalist myself. I don't think that it's appropriate here to be focusing on whether or not she's a journalist, because I think it's already essentially decided in the law that there is no special privilege for people who identify as journalists versus anybody else. I think, just because you're a journalist, it does not give you any special right to express yourself. Freedom of the press isn't referring to, journalists, it's referring to the printing press. So from a legal point of view, I don't think there's any reason to try and parse whether she's a journalist or not. I think everyone should be able to to document police conduct, right? Like we're all journalists now that we have smartphones, and there's nothing special about somebody just because they have a press badge. So the real issue here is whether creating an exclusion zone like this in the first place that you can exclude all members of the public from is acceptable. And I don't know that it is. I think people should be able to get close to the site where something like a pipeline is being built, and if there is such an exclusion zone, it should be really small. I just think this is a settled question, like legally. This came up in National Post, it came up in Vice Media, so we already know that there's nothing special about journalists' freedom of expression, and that's just how it has to be. But that doesn't detract from the fact that we need to be able to document police conduct, and so I hope that that particular question is recognized by the courts.
But what about this difference between how they treated different journalists, the
That's
police?
that's on them. I mean, they don't know the law, right? So, if she, no, it's either everyone should be able to access that site and document it, or they shouldn't. And by the way, like if you're going to start parsing whether somebody's an activist or a journalist, Amber Bracken is more of an activist than a journalist, but I would say all journalists are to some degree activists, right? Like even the person trying their hardest to be balanced and fair at the end of the day, it's very hard for your bias not to come into that. So in my opinion, like following the Narwhal and Amber Bracken, she falls way more to the activist side than say like a Globe and Mail reporter, but it just shouldn't matter. It just shouldn't matter. You either should be able to express yourself there and document things or not. Alexander. Oh, sorry, go ahead,
No,
Christine.
I was gonna ask Alex what he thinks.
Yeah, I like your last comment. Well, everything, I agree wholeheartedly with both of you. Christine, I liked the fact that you asked Josh about that critical detail, which is really about the arbitrariness, if I may say so, on display on the part of the officer, making this determination based on the behavior of those involved. That's not to me a relevant consideration. There's a difference, of course, between acting in an unlawful manner, causing a disruption, perhaps violating certain laws under the criminal code. So you'll forgive me, of course, for referring to my experience dealing with police officers in cross-examination in my role as a defense lawyer. But part of it does come down to, or let me put it this way: often there are questions to be asked, and they really with respect to police conduct and why certain decisions were made, particularly if it's not a very chaotic situation. We can, of course, be sympathetic if things are if things are dynamic, but without knowing more, it's hard to say whether or not that sort of arbitrary snap judgment about how how to what extent they were behaving like journalists, I think is again should raise some eyebrows. So I agree there with Josh about the fact that look, we should have the ability to document what it is we see. If we're not trespassing and if we're not violating any ordinance or law, there should be no issue. And it's not for the police to decide based on how you're behaving whether or not you resemble a journalist or not. I think
Mhm.
that's silly.
I mean, I guess in this case they were all trespassing since they were all violating a court order. Okay, well, we've got to go to break now, but when we come back, we're going to give our bad legal takes this week.
All right, I'll go first. So my bad legal take goes to Heritage Minister Mark Miller for his initial response to Conservative MP Sandra Kobina on one worrying aspect of Bill C-15, which is the budget bill. So this happened in committee recently, and there's a viral video of it. So I've actually written about this aspect of C-15, so I'm glad it's being taken up by politicians. It's actually really hard to believe, but what C-15 does is buries within it a provision that would give any minister the power to suspend the application of any law other than the criminal code for up to 6 years for any individual or business. And rather than this being coming in the Canada Gazette, they can in some cases do this secretly. And this includes every act from the Conflict of Interest Act to environmental regulations, any law essentially. And to me, that's like giving the minister king-like powers. So Ms. Kobina asked Mr. Miller, why should one individual minister be allowed to bypass 150 years of Canadian laws and exempt a person from their choosing? And Miller responded, that's not what's happening. So that's the bad legal take here, because that's exactly what's happening. Miller, I think, was being a bit too cute, because after Kobina pushes back, he says, well, it doesn't say people are exempted from 150 years of laws. It just says any federal law except the criminal code. There's no mention of the years. So he has to essentially admit that she's right. And he says, I think it's helpful to have, and that it would be used very judiciously. So bad legal take to Mr. Miller, trying to suggest C-15 wouldn't give ministers the power to exempt anyone from any law since Confederation, other than the criminal code, since that is exactly what it does. Christine, let's hear yours.
Okay, my bad legal take goes to a random person on Twitter or on X, and also to myself because I shouldn't get into fights with random people on X. So here's what happened. In an X post, I said I was talking about our Emergencies Act decision and, bragging on X. And I said that now two levels of government have confirmed that the Emergencies Act use was illegal and unconstitutional. And this very annoying woman on X who has, said this to me before, her name is Kimmy B. She said it wasn't illegal, it was unreasonable. And I think she believes this is some sort of own. It is not. Of course, the use of the act was unreasonable. Reasonableness is part of the standard to use the act. So arguing it's unreasonable, so using it in an unreasonable way is actually using it unlawfully. So the other thing is when you enact a regulation that violates Canada's charter, which is the highest law of the country, those regulations, if they violate the charter, they're also unlawful. So sometimes colloquially on X, when I post things like this, I'll say, we sue the government over illegal laws. So I replied saying this, and I said, it was unreasonable, but if you use it unreasonably, that's using it unlawfully. And so then she said, unlawful and illegal are two different things. And okay, Josh, do you know the difference between something unlawful and illegal? Don't
I
answer
didn't think
that.
there was any difference. I should know.
Illegal is a sick bird, but I mean, they actually technically have a slight nuance difference, but it's very pedantic. Courts generally would talk about a rights violation or an administrative overreach or an invalid regulation as an unlawful regulation. And then when we use the term illegal, it more generally refers to a crime or prohibited conduct by an individual. But again, this is quite a pedantic difference when we're talking about an ex post, especially when I say something like, we sue governments over illegal laws. I wouldn't say we sue governments over unlawful laws because it just doesn't sound good. But look, I will concede that it is good to be precise. So I think if we're talking about it in a highly technical and not meaningful way, then two courts have now confirmed that the use of the Emergencies Act was unlawful and unconstitutional. But look, Kimmy B said, she's trying to say this as in it wasn't that bad. And there is just not a meaningful difference between a government act that was unlawful and a government act that we say is illegal. Both of them are pretty fatal. Both of them are absolutely fatal to the government action. Neither of them are defensible. And trying to parse out that difference is really completely meaningless. So I guess a bad legal take to me for even trying to engage with some random Twitter user about this difference. But yeah, that's my bad legal take a little bit to myself, but mostly to Kimmy B. Alex, I think you had a bad legal take this week where you were going to use your background in criminal defense work to explain an assault charge that was just dropped?
Yes, yes, I do indeed. And so this is an interesting one. It's also quite troubling if you care about the subject matter, and frankly, I think we all should. This dates back to July of this past year, 2025, out of Toronto. And without delving too deeply into the details, suffice to say that there was this woman by the name of Jennifer Claremont, and she was arrested and charged on July 4th, 2025. And she was arrested for assault. And assault's an interesting an interesting offense under the criminal code because it's a bit of a wide net. But the point is, and this is the crux of it, she was arrested and charged for assault because she spit on a Jewish person, called him a Zionist pig. So this is obviously a hate motivated assault. And of course, this was also well documented. So it was incontrovertible what had happened. And so here I might be a little bit pedantic, but it's important because once we understand how this was dealt with, how it was disposed of, in other words, we can get into how it was dropped, if dropped is even the right word. In the end, this individual, Miss Claremont, her punishment, if you will, was that she was to enter a 6-month common law peace bond. Now, a common law peace bond is not the same as a peace bond under the criminal code, but before we get to that, a peace bond is a promise. In other words, it's a document that the individual signs promising to be good. It's almost, I won't use the word childish, but it's quite like getting in trouble and getting a slap on the wrist, where you just say that you'll be on your best behavior and you'll go on your merry way. And frankly, I think that that's an entirely inappropriate disposition. That I think that if you're going to, again, I do speak from experience, if you are so motivated to commit an assault and the facts are not in dispute in any which way, something more significant and more serious is warranted in terms of the punishment. And again, I've seen less less scandalous, less dramatic matters where an individual was charged with assault receive a far stiffer and harsher penalty. Assault is if we want to simplify it, assault is the application of force, that is making contact with someone that is non-consensual. So it, it captures a lot. But when you spit on a person and you are motivated to do so clearly by hate, a stiffer penalty is certainly warranted. Now, a common law peace bond, as I say, is more archaic. It's older than the criminal code, which of course is a statute. It's a written law. A common law peace bond goes back centuries. And again, as I say, you promise to the court to be on your best behavior. And in her case, the carrot and the stick here, the carrot is that she gets to walk free. Critically, Christine, it's not a criminal conviction. She's not been convicted of a crime, which is preposterous. Uh, she she risks at most having to pay $500. So if she breaches the terms of that peace bond, which, as I say, is just to be on her best behavior, and the magic words you'll hear are to keep the peace and be of good behavior, she will forfeit that $500 and, of course, may find herself being charged with a related offense under the criminal code. I believe the section is 127. It would be the offense there would be the breach of a court order. But the point here, to boil it down, is that spitting on someone, which is a disgusting act, it has sanitary implications, but it's really degrading, demeaning, and then to, of course, top it off with a slur is something that definitely deserves a stiffer penalty. I see no other way around it. And so the bad legal take was the fact that she got off not quite scot-free, but it really was nowhere near the appropriate penalty in this case. And it's disappointing because the point is that it should have a deterrent factor. The person being sentenced, Christine, to sum it all up, when we sentence an individual for an offense, we're doing two things at once, or at least we hope we are. We are We are ensuring that that person, that justice is served with respect to that one person, but also it's to deter others from doing the same thing. They'll know that that these sorts of acts come with consequences, and that's not what happened here. So that, of course, is a very bad legal take on the part of the court giving her this peace bond.
But the real question is, was the man she spit on a journalist or an activist?
He was. We know who he was, and he is for sure.
Right.
Well, very strong, bad legal take to start off your work with the CCF, Alexander. So thank you for that. That's the end of the show. As usual, we ask you, if you haven't already, to rate us, review, and subscribe. And just a reminder, you can support our work by subscribing to our YouTube channel, by following us on X, or by visiting our website, TheCCF.ca, and signing up for our Freedom Update newsletter. The CCF is a nonpartisan charity funded by your donations, so please do click that donate button on our website if you can. Thanks for listening.